Good morning and welcome to Flash Briefings by Manning Fulton. Today's topic, COVID's impacts on construction and commercial real estate, is the second of Manning Fulton's Flash Briefings, designed to provide you with key legal insights in support of your business objectives and to do so in a manner that you can quickly digest. My name is Alan Dickinson, the Director of Client Relations here at Manning Fulton, and I'm very glad you can join us this morning. It's my pleasure to introduce my colleagues Judd Welburn and Gray Wilson, two exceptional litigators who will be leading today's session. One housekeeping note, you will have the opportunity to submit questions this morning by typing your questions into the questions pane of the webinar's control panel, and we encourage you to do so at any time during the presentation. If we are unable to address your question during the session itself, either Mr. Welburn or Mr. Wilson will contact you directly following the presentation. And with that, I turn it over to Judd.
Thank you, Alan, and good morning, everyone. We certainly appreciate everyone joining us early this Wednesday morning for a few minutes. I'm Judd Welborn. I'm a member of our litigation group. I'm joined, as Alan mentioned, by my colleague Gray Wilson, also a member of our litigation group. Gray and I spend a fair amount of our professional time litigating construction and real estate cases, drafting and negotiating real estate and construction contracts, and we wanted to spend a few minutes with each of you this morning talking with you about some of the things we're beginning to see flow from the fallouts of the ongoing COVID-19 pandemic, and hopefully offer you some practical insights as to how to address some of these issues. We encourage questions along the way. Feel free to use the chat feature, as Alan mentioned. To the extent we don't have an answer, and there's always a chance we won't, we will get you one. And also, if we aren't able to get to the particular question you have today, we can certainly handle that after this session ends this morning. As an initial matter, I think it's important that everyone understand that there's a lot we still don't know in the litigation arena. While it feels like we've been dealing with the effects of this pandemic for a decade, in actuality, it's only been about 6 months. And in the litigation arena, the equivalent would be about a second, say, in most other industries. So 6 months to us litigators, not a lot of time to have allowed courts to work through some of these issues, though, as we'll talk about in just a moment, we're beginning to see some of the early stages of the litigation efforts that will be ongoing out there around the fallout. Anyone who has had any personal experience with litigation knows that courts move slowly, and we certainly don't expect the issues arising from the pandemic to be any different in that regard. I say that all of that I say to simply tell you that while we're going to talk a little bit about trends we're beginning to see emerge, there still just aren't a lot of reported decisions from courts around the country on some of these issues as we sit here today. We are seeing claims filed. We certainly are seeing disputes arise, most of which remain in sort of a pre-litigation posture, if you will. That said, there's a lot of literature out there that suggests the experts are thinking that there will be a cascade of pandemic-related and pandemic-driven litigation in the next couple of years of all shapes and all sizes. What we're seeing typically today deals more with things like business interruption insurance, workplace safety-related claims, employment-related claims, none of which, of course, are the focus of today's talk. We have people here who are dealing with those, so if you have those questions, certainly feel free to reach out. One other note before we begin talking about some of the trends around the country is we're also seeing some trends emerge with respect to the economic impacts that the pandemic is having, especially with respect to local and state government projects. Anyone who has been following the NCDOT, for example, knows the projected revenue shortfalls, which overlaid on an already tight revenue situation, has made for some very difficult conversations with respect to projects going on suspension lists. We are also seeing, to a certain extent, some adverse impacts in the capital markets. And for those of you who develop property for a living, you are living that every day, and we certainly are seeing that ourselves and are here to help in any way that we can. But I'd like to talk briefly this morning about some of the impacts we're seeing on construction contracts, development agreements, real estate contracts, real estate transactions, and frankly, ongoing construction projects, because it's having a pretty widespread impact across each of those areas. It's obviously brought a lot of uncertainty to the construction and commercial real estate industry, particularly with regard to the impact on existing contracts and performance obligations. We've seen construction projects be shut down because of COVID-19 outbreaks. We have begun to see delay claims being made that are directly attributable to the impacts of the pandemic. But by far, the most prevalent issue we are seeing in these early stages revolves around this issue of a force majeure clause, or in some cases, the common law doctrines that are invoked in the absence of a force majeure provision of frustration of purpose or impossibility. And unless you've been living under a rock for the last 6 months, you've probably heard or read about force majeure provisions in contracts. One of the few good things that has resulted from the pandemic is it has caused lawyers like Gray and me to actually write and publish information on matters of relevance to clients, and we've done a lot of that. You can do a quick Google search for force majeure clauses, and you will find a treasure trove of information on the internet free of charge that will help you better understand some of these topics to the extent you have an interest. The force majeure provision as a general rule and as a matter of contract law is a situation where a party to a contract has a defense against performing under that contract where that performance becomes impossible due to unforeseeable events outside of the party's control. These are often referred to acts of God provisions, if you've seen that buzz phrase or that language. Gray's going to talk in a little bit about some proactive tips on drafting contracts, contract planning in the age of COVID, which frankly have application beyond COVID. I think we're learning that these force majeure provisions are critical, even though they aren't necessarily widely litigated, and an ounce of prevention is worth a pound of cure, so to speak, when it comes to how to plan for these contract provisions in the future. They typically vary, these force majeure provisions, that is, in what is covered, and are oftentimes, and to the extent they've not been in the future, in the past, they certainly will be in the future, subject to extensive negotiations. Most of these clauses include a finite list of events in an attempt to narrow the clause's applicability, though we do see some situations where there are these catch-all phrases that basically says any other event not herein defined. The most common things we're seeing are things that you would expect in most contracts in the construction and real estate development arena, things like natural disasters, war, terrorist acts, eminent domain, changes in the law, etc. We are seeing very few that actually use the buzz phrase pandemic or essentially any health-related issue or public health-related issue that may come up. We are confident that will be included in more contracts in the future, and we're certainly doing that now for many of our clients. But at the end of the day, the analysis really comes down to a determination of whether these acts were beyond the party's reasonable control. And of course, with the governmental entities around the country issuing various containment strategies and orders and other directives, there has been a trickle-down effect, make no mistake about it, on companies' abilities to fill contractual obligations, especially in the construction and the real estate development arena. Leaving aside the broader economic impacts, there are some practical day-to-day concerns that are continuing to arise even today, 6 months in. As I mentioned a moment ago, these common law doctrines of frustration of purpose and impossibility usually kick in when there is no force majeure provision laid out in the contract. So if you're in a particular situation with regard to a particular contract and you don't have a force majeure provision, you are not out of luck. Indeed, there are lots of cases out there. It is an evolving body of law. I suspect it will become a very hotly contested area of the law in the next couple of years. But in those situations where you don't have that contractual protection, there are these common law doctrines that sometimes will afford you relief from performance in the right circumstances, and we're going to talk about those in just a moment. We have not encountered any North Carolina or Fourth Circuit cases in the time of COVID that discuss the impact on the applicability of force majeure provisions or these common law doctrines. And that's important because until we do, we don't have any real good insight as to how the courts of this state will interpret those types of provisions. However, we are seeing some cases handed down around the country that have begun to allow us to glean some potential trends that we think may be instructive to our courts. Combine that with some general principles of contract law and how our courts have typically interpreted contracts, we think we're beginning to get a pretty good handle on how those issues may be resolved once they reach our appellate courts, both on the state level and on the federal level. But as a general rule in North Carolina, and we think this rule should prevail when the courts in this state begin looking at these provisions, but the general rule is those force majeure provisions are going to be construed very narrowly and will generally focus on whether the contract language specifically names the event resulting in non-performance. For example, if your force majeure provision references a pandemic, an epidemic, viral outbreak, adverse governmental action, things of that nature, we feel pretty confident in saying that courts are likely going to find COVID-19 to be a triggering event. That being said, we are seeing some cases around the country where plaintiffs are rushing into court asking for courts to apply these provisions more liberally, both in terms of force majeure and the common law doctrines. And obviously, the litigated cases will likely involve force majeure clauses that don't include the buzzwords I just mentioned. Indeed, they will probably have language or provisions that say things like a lack of an ability to perform, or disruption of a supply chain, disruption of, say, labor force. There may be a reference to act of God, and then these catch-all phrases. If you have contracts with that language, it would behoove you to seek legal counsel before seeking to enforce them, because again, we think there's going to be a fair amount of argument around the enforceability or the applicability. The trends that we're seeing, as I mentioned, suggest that there's going to be close scrutiny given to the language itself, both on the force majeure side and on the common law side. On the common law side of frustration of purpose and impossibility, it appears as though courts are beginning to review these contractual arrangements with an eye toward the issue of whether or not the parties assumed the risk of changing market conditions and governmental restrictions that have resulted from the pandemic. And it's a very fact-specific, case-by-case analysis that will literally turn on the very words of that contract. But there has to be some anticipation, some reasonable ability to predict these issues that have flowed from the pandemic in order for those common law doctrines to kick in. Now, most of this litigation that I'm referencing still is in the preliminary stage of the overall process. That being said, we have seen some decisions forthcoming from several courts that I think are particularly instructive and helpful. One in particular that I would commend to each of you is the HITZ Restaurant Group bankruptcy case in the Northern District of Illinois. In that case, a debtor, an owner of a restaurant group, asked the court to enforce a provision in their lease that contained a force majeure provision that basically excused their rent to pay, excused their obligation to pay rent post bankruptcy filing. And in that particular force majeure clause, the language read, quote, "Landlord and tenant shall each be excused from performing its obligations or undertakings provided in this lease in the event, but only so long as the performance of any of its obligations are prevented or delayed or hindered by laws, governmental action, inaction, or orders of government." Now, in that case, the bankruptcy court, as you might expect, found that the pandemic triggered that force majeure language. But in a great example of how courts will sometimes go out of their way to fashion equitable relief when otherwise none may be had, they actually got into the weeds here and they said, okay, you don't have to pay post-petition rent because the government shutdown clearly impacted your ability to generate revenue at a restaurant in order to pay your rent. However, because you could continue to operate takeout, the court said you had some ability to pay rent. So in that particular case, they actually said force majeure was triggered, but you're still going to have to pay rent commensurate with the proportion of revenue you could generate through takeout service. I know it's a little ticky-tack, but it's an example of how courts are really going to look holistically at these situations when enforcing these force majeure provisions. Lest you believe that be a trend that will prevail across the country, I should point out that there was a very similar force majeure provision litigated recently in the federal district court in the Southern District of Florida. Literally, same provision. Florida court in that particular case said it was not triggered. It was the Kirkland's case, and basically they said Kirkland's was unable to link the non-payment of rent to the government regulations. I have not read the background pleadings in that case. I have not read the briefing, but it is interesting to me that you had essentially identical force majeure provisions in two federal courts reading them completely differently. But what it tells us is that those folks who are seeking to enforce these force majeure provisions are going to have to demonstrate that the pandemic or the related governmental orders stemming from the pandemic are directly implicated by the language of the contract. And it also, based on my quick read of these cases, suggests that you're going to have to be able to demonstrate that a COVID-19 related event has resulted in or directly led to your inability to perform. It's not enough to say the markets are bad. It's not enough to say that the labor market is tightened up. There has to be a direct link to the effects of that pandemic. There are some other cases that are out there around the frustration of purpose and impossibility. There's a Northern District of Ohio case involving a settlement agreement that was entered into pre-pandemic, where the court said it would enforce the settlement obligations because the parties could have foreseen the economic implications of the pandemic. The settlement agreement in that case was entered into about a week and a half before the first national state of emergency declaration entered by President Trump. The court in that case said, if this had been a year ago, we might be more sympathetic, but just arguing that the economic climate is different does not mean you should not be held to your bargain in performing the obligations under this settlement. The only other case I'll mention briefly before we turn it over to Gray is it's actually a case that is pending in the Eastern District of Virginia. It is the Pier 1 bankruptcy case. You guys on this call have probably been following that, especially those of you who operate in the commercial real estate arena. In that case, the court did not accept Pier 1's invitation to interpret the force majeure provision in the leases at issue. Interestingly enough, though, the court did grant Pier 1's request to delay continued payment of rent because they found there to be no feasible alternative in light of the fact that the continuing government orders were keeping these stores from generating revenue to pay rent. It mentioned the financial challenges around these shelter-in-place orders, but let me be clear, it did not specifically enforce the force majeure provision, nor did it say we find the doctrines of impossibility or frustration of purpose here to apply. But what they did say was the resulting inability of these debtors to sell product in these stores or find other means of liquidating inventory did afford them some relief. And admittedly, again, there's a lot of equity involved in these arguments, but that's, we think, a trend that will likely continue. We've heard some rumblings that force majeure claims on construction projects are coming. We've not seen those matriculate through the dispute resolution process as of yet, but we believe some of these same principles are likely to apply to that analysis when they do. And finally, before I hand it over to Gray, I would just like to say, if you feel like you've got a situation where you are unable to perform, or you have an opposing party to a contract who might be unable to perform. Of course, it's imperative to look at that language early and thoroughly, considering whether these defenses might apply, and communicate with the other side. Get out ahead of it. There is no good reason to delay that conversation. Of course, we are happy to assist you in that effort should the need arise. With that, I will turn it over to my colleague, Gray Wilson, who's going to talk a little bit about proactive steps in contract drafting in the age of COVID, and talk a little bit about the state of government orders around COVID-19. Thank you very much.
Sure, thanks, Judd. And I think the point you made about force majeure, needing to prove that your inability to perform is the result of something in the force majeure clause is a good one. You can have the most specific reference to whatever the event in the world is in your force majeure clause. You can have a force majeure clause that says, if the COVID-19 pandemic prevents us from being able to perform this contract, then performance is excused. But you still got to prove that the reason you can't perform is actually the COVID-19 pandemic. And I think that's going to be an issue that is litigated pretty heavily. The construction industry in North Carolina, at least, was pretty well exempted from a lot of the governmental, stay-at-home orders as an essential activity. And so, you should, if you're a contractor, you should expect an owner to respond. I don't know what you're talking about. There was no government order saying that you couldn't perform. And if you're a contractor, you need to be thinking about, well, how is it expressly tied to things related to this pandemic that we couldn't perform. And so, I think that's going to be a really interesting issue to see how the facts play out on that and how the arguments play out on that as these cases get litigated. So, as Judd mentioned, I just wanted to talk about a couple of ideas about, how you might want to take a look at your contracts, particularly construction contracts, and in light of what's going on in the world. The obvious one is these force majeure clauses. They're rightly getting a lot more attention in negotiations than they may have in the past. And so it makes sense for folks to take a closer look at your contracts and make sure you understand how it's going to work if we have a second wave of this thing in the fall or the winter that makes it impossible or that shuts construction projects down at some point. Who bears the risk of that? What does your contract say about that? And so as you're negotiating contracts over the next few months, or as you're looking over the contracts you already have in place for ongoing projects, that's something to be thinking about. Now, that's not to say that that you necessarily need to make changes to your contracts. If you're a project owner and your contract has no force majeure clause at all, your contract has no force majeure clause at all in it, that might be preferable to you, since that essentially means that the contractor's bearing the risk of force majeure events like shutdowns. Obviously the caveat there is what Judd mentioned before about the impossibility arguments, frustration of purpose arguments, things like that are still out there, even if there's no force majeure clause. If you're a contractor and and your contract says you're essentially excused for any kind of delay that isn't within your control, that might be preferable to having a detailed force majeure clause that says, you are responsible for this, you're not responsible for that. So, the point there is just to make sure you know what the status quo is in your documents before you go into negotiations and start changing things. Because, it's always helpful to clarify things, but, you want to make sure you're clarifying them in a direction that is helpful to you. And you want to go into those negotiations understanding what the baseline is. But in general, it's better for contracts to be clear about who's bearing what risks. And I think those are going to be discussions that a lot of owners and contractors and subcontractors are having as they work through these issues over the coming months. The only other point I wanted to mention on contract drafting, I know we got limited time here, is that one of the choices that parties make in construction contracts and just about any contract really is dispute resolution. Do you want to arbitrate disputes? Do you want to go litigate disputes? Do you want to do it in a private arbitration forum or in the courts? Excuse me, you know, there are good reasons to go in both of those directions. I think that the existence of this pandemic is probably pushing the balance towards arbitration more than litigation because, well, for a couple of reasons. One, litigation usually ends in the end point of that is a jury trial, right? There aren't any jury trials happening right now. The government is not allowing 12 people to sit shoulder to shoulder in a box to decide civil cases anytime soon. Litigation in general takes longer than arbitration, and that's only going to be exacerbated here. And the other sort of aspect of that is arbitration generally, because it's a process that's agreed upon by the parties. Parties can adjust it to fit whatever the needs are of the moment a lot more easily than you can do when you're working with courts that are a bit less flexible. So to the extent that you're on the fence about that, I think that the pandemic situation should probably push you a little bit more towards choosing arbitration as your dispute resolution method rather than litigation. And we're happy to talk with anybody about that if you've got questions about it. We've only got a couple of minutes left, so I just want to tick through a couple of the government order sort of restriction type things that are out there right now. Most of the things that were in place early in the pandemic have started to be eased in some respect, to the extent that they restricted construction activities in the first place. As we talked about before, a lot of the initial stay-at-home orders exempted construction. So not a huge impact there, or at least direct impact. Obviously, there's supply chain impacts and things like that. But I did just want to mention three things very quickly that I think folks might want to be aware of. First is the CDC moratorium on residential evictions. So earlier this month, facing the pending expiration of the eviction moratorium that had been established by the CARES Act, the CDC issued its own moratorium on residential evictions that'll last through the end of the year. So if a tenant says, basically, I can't pay, and if you evict me, I'm either going to be homeless or I'm going to have to go live in close quarters with somebody, then that tenant cannot be evicted. Of course, it can't be evicted for failure to pay rent. You can still evict a tenant for other sorts of violations of the lease. So to the extent any of you are involved in residential or multifamily projects, that's something that you certainly want to keep an eye on. The existence of that order and whether it's going to be extended past the end of the year. The second thing I want to mention is that OSHA and the State Department of Labor are continuing to issue updated guidance on COVID-related protocols for construction projects specifically and for the workplace in general. So to the extent you're not keeping track of those are worth looking into. And then the third thing I'll mention is that earlier this summer, the North Carolina legislature enacted House Bill 118, which essentially provides limited immunity for COVID-related claims. It says that no person or company can be sued on the theory that they caused someone to contract COVID. Of course, there's exceptions to that. This won't protect you if you're grossly negligent or intentional in allowing folks to contract COVID. So it's not a license to ignore common sense and reasonable guidance that's out there for trying to mitigate COVID risk. But hopefully it will cut down on the sort of frivolous lawsuits that folks were really worried about at the beginning of this thing. So we're right at 9 o'clock. I'll stop there. Let Judd close us out if he's got anything to add.
Nothing further, Gray. We appreciate everyone's time this morning. And again, feel free to reach out to us directly or to Alan if you have any questions or needs. I hope everyone has a great day.
Thanks, Judd. Thanks, everyone.